The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to help yourself, your family, and in some cases, your business. We continue to provide information and resources that'll help you decide whether you need or want to contact a lawyer. As we tell you, perhaps you'll determine that you might be able to handle some issues yourself. If you do decide to deal with professional counsel, you'll be better prepared, and as a result, so will the professional you select. Either way, of course, our goal is to help you save time, money, and hopefully achieve the best possible results. We want to always welcome and thank David Bazar from the Bazar & Associates law firm in East Providence, who continues to provide information and resources for us on the various issues that we tackle. And today we both want to welcome our special guest, attorney Kevin Nerney, who is with the Rhode Island Developmental Disabilities Council, and he's going to be weighing in on our topic today, which is guardianship. So most often people think about guardianship initially in the context of children. However, guardianship can also pertain to adults in very certain circumstances. We're going to explore those today. What does that constitute? What should be the extent of control? It's certainly been a contentious and somewhat sensitive issue. It's being challenged and changed in the courts. So we're going to discuss the process, the circumstances, the alternatives, and the things that will affect you and some of your friends and family. So, David, why don't we start with you? Guardianship in broad brushstrokes. Process, what's it involved?
So if you're talking about an adult guardianship, the court is supposed to take a look at it and put something together that's the least restrictive on the ward, the person who's going to be under the guardianships, so that the control is somewhat there if they can. So first thing they ask in the petition in the form is, are there other documents that are in place that could take the place of a guardianship, power of attorney, healthcare power of attorney, those types of things. And then there are 4 areas that they look at that a person may need help with. They need help with decision making on financial issues, on medical issues, on residential issues, relationship issues, who they should be able to associate with. And the goal of the guardianship is to give help to the ward, but do it in the least restrictive way that you can.
Which is a good springboard for, now Kevin, you deal with the Rhode Island Developmental Disabilities Council. We understand that you've been actively involved with what goes on in Rhode Island, but certainly you can speak to what happens with this community. What are the similarities and differences?
Sure. So the Rhode Island Developmental Disabilities Council is an advocacy organization. We're federally funded. We have 2 sister agencies within the state, the Disability Law Center, which does individual advocacy, legal work, and the Sherlock Center, which does research and kind of does educational related things. So we've worked with the Disability Law Center because we found that in Rhode Island and nationally, people with intellectual and developmental disabilities are put under guardianship, oftentimes when it's not necessary.
Right.
So at a national level, 58% of people with intellectual and developmental disabilities between the ages of 18 and 22 are under guardianship. And that's a very high number.
Right.
Yes.
In Rhode Island, we're a little bit better than the national average. I don't know the numbers off the top of my head. But Rhode Island recognizes that when you put somebody under guardianship, you're removing civil rights. And because of that, they want to avoid it when possible. So Rhode Island's law is actually very, in my opinion, it's a very well-written law. It allows for limited guardianship, as you had alluded to, so it's not taking over all decision-making for an individual. It also can be in just certain areas or only for specific reasons within an area. However, again, nationally and sometimes even in Rhode Island, we find that judges award guardianship, a greater degree of guardianship than potentially even what was requested.
Yeah.
We actually have somebody who sits on our council who applied for limited guardianship but was granted full guardianship.
Yeah.
And so we are here to protect people's civil rights and to advocate for people's civil rights. So what we're trying to do is make sure people are aware of the alternatives and really push for people to use those alternatives so that each individual can determine their own lives, make their own decisions, and really be in control the same way any other person would. One of the big issues is when people who are not in the field, oftentimes when they see somebody with a disability, they instantly think they don't have the capacity to make decisions. Or if they think somebody's made a poor decision prior, then that should remove their capacity to make decisions moving forward. So we do really want to focus on the potential alternatives that are out there.
So before we talk about the alternatives, what is involved with, why would someone want to become a guardian? How does someone do it? And what's that, is that a long and dragged out process,
well,
an expensive process?
So those are a couple of very good questions. One is it a long process? And that kind of depends. Depending on the city or state you're in, because you have to go through probate court, right? So it's not Superior Court, it's your local court. Some probate courts, particularly in cities, meet multiple times a month. Others in towns probably only meet once a month. So if you have to go through multiple hearings, you are talking about a months-long process. In addition to that, the judge obviously will make the ultimate decision, but they need more information than often what the parties can bring to the courtroom. So they'll appoint what they call a guardian ad litem. This is a temporary person who will go out and meet with all the people that are involved and try to get a better understanding of what's really needed here. And they're often attorneys as well. The guardian ad litems are often attorneys as well. As far as cost, yes, there is a monetary cost. You don't have to hire an attorney, but in most legal matters, you probably should.
Deb likes to say, is this a do-it-yourself job?
Exactly.
This really is not a do-it-yourself job.
There are very few legal matters that are a do-it-yourself job. Yes, there'll be that cost. There'll be the cost for the guardian ad litem, who again is often also an attorney. There's filing fees. You do have to, once you are awarded guardianship, and this is really important as well, you are inviting the state into a personal relationship. If you're the parent of an adult and you want guardianship over them, if you get guardianship, that person is a ward of the state.
Right.
So you now have to report to the state, the court, at least annually on different things, including finances and health care.
And which is one of the reasons we always encourage people, not with the disability situation, but before you become incapacitated, to do some of these other documents that let you appoint someone you trust to do it, so that you can avoid that relationship with the state saying, okay, you're going to appoint somebody for me, and they're going to report back to you every little thing that I wanted them to do and that they did for me.
Yeah, so it can be burdensome. Some people don't have an issue with that, and it works. And, frankly, there are situations where a guardian is going to be necessary. So I don't want to say it's 0%. I just think, again, that 58% number is way too high nationally. So other costs, though, beyond the monetary costs, particularly in our field, and it might be a little bit different when you're dealing with elders. That's a slightly different situation. But in our area, I often see guardianship being applied for, and the parents, because let's face it, I'm a parent too, we're very protective of our children, right? So it's protection first. I often see a rift between parents and siblings of the person that they want to get guardianship over, where the siblings are saying, my sister or brother has gone through school, they have friends, they want to live their own life, why are you trying to take away their right to, and so that's a family cost, to some degree. Also, sometimes I have seen it happen when the parents are getting or have already been divorced, and it's really almost a rehashing of the divorce, and they're using the child as another pawn in that instant.
I have seen that situation, having done family court too, and then the people are divorced, and the one parent who was given custody, now the child's over 18 in Rhode Island, and they use a guardianship to continue to keep the other parent, if they can, away from that child, and to the detriment of the child in many
oftentimes. So another relationship cost is either the child resents the parent that got guardianship, or that guardianship is used to make the child resent the other parent.
Correct.
And so the costs aren't just monetary. There's also a privacy. Probate court is public. So
point.
some places do automatically seal, not everywhere. You can request to have some things sealed, but it's, again, not automatic. So your information is now public. Anyone can go and research that. Oftentimes they're in a town hall. And so somebody else waiting for their case could be sitting there listening to all the medical and psychological information be presented to a judge.
So you alluded to, and you did too, David, that there are alternatives. So what is in place? I know you've said that there are some recent changes that are afoot, not just in Rhode Island, but in other states. What are the alternatives, and how do you prepare people for them?
The main alternatives, it depends on what it is you're looking to do. And oftentimes, not always, but oftentimes, parents want guardianship for a specific reason. I want to make sure they're healthy. I want to make sure that if they're in the hospital, they contact me. If they're over 18 and still in school and they have an IEP meeting, I want to make sure I can go to that. So there are other documents that will allow this to happen. For healthcare, there's a healthcare power of attorney in Rhode Island, or healthcare proxy in Massachusetts, which allows, when the person is incapacitated, it allows somebody else to make decisions for them. Everybody should have that, disability or not. Every citizen. The other is a HIPAA waiver. HIPAA is kind of the Healthcare Information Privacy Act. So generally, a general physician or a hospital should have a HIPAA waiver. The child can sign over the right for parents to receive information. I find oftentimes that's really what parents want. And again, I would suggest this, disability or not, if your child turns 18 or 19, especially if they're going off to college, they might want to have signed that to you so that you can still...
When we do an estate plan, the components of the estate plan are not just the will of the trust, it's the financial power of attorney, and as you say, we also do a HIPAA authorization and a healthcare power of attorney, and we sort of do belt and suspenders with the living will as well.
Right.
What does that mean, belt and suspenders, David?
Because
Better be particular.
the healthcare power of attorney not only authorizes someone to make decisions consistent with what you want, we put what you want in that healthcare power of attorney, but the living will, which predated the healthcare power of attorney in the sense that it was available before you could even have a healthcare power of attorney, did the same thing as far as stating what your desires were towards the end of life, or if you're in a persistent vegetative state with no hope of recovery.
Right. And that's actually really important, because the healthcare power of attorney is the more powerful document. That person ultimately makes a decision, but the living will helps inform them as to what those decisions are. And I have to say, legal or not, having that end-of-life discussion is really important as well. Not for the person, not so much for the person who's actually going to be passing away, but for the family members that know they're following your wishes. You release them from a major burden.
Yes,
when you
guilt of having to make that decision.
So that's really important as well. Again, disability or not, we're talking about guardianship or not. So that's on the healthcare side. On the financial side, many people that we represent, their total monthly income is around $700. It's their SSI check.
Which is, I'm going to say SSI amount.
And so there's really not a lot there to worry about. But there are some alternatives. A joint bank account. With electronic banking now, you could have, say, a savings account, and you just move money every month to a checking account that the person can use wherever they want. And if there's something that isn't right, or maybe even if it is right, you can get electronic alerts to your phone. So that's one alternative. You can help people by helping them, if they want you to, of course, you need their permission, to help keep an eye on their finances. There's credit opt-outs. There's fiscal power of attorney, like we talked about before, where you actually give somebody the authority to act on your behalf. On the education realm, just like there's a HIPAA waiver, there's what I call a FERPA waiver. FERPA is like HIPAA, except it applies to educational records. I developed myself a FERPA waiver, so if a child turns 18 but they're still in high school, which a lot of students are, they can sign that over to their parents, so the parents can make sure they're going to school and getting good grades and coming to IEP meetings and everything else. Since then, that was a while ago, I believe most school districts in Rhode Island now have their own, so you can just go to them. They copied
your form.
They may have. It was pretty good if I just say so. So that's an alternative for education. Relationships, that's a really good one.
Prickly, I would imagine.
Well, what parent hasn't seen their child maybe date somebody that they didn't want them to, or hang out with a friend that they thought, ooh, they're really not that good for you? That's just life, and it happens for everybody, and everybody needs to be able to kind of make those mistakes. Now, if you get a document saying, aha, I've got guardianship over your relationships, so what? Are you going to be able to stop them from leaving the house? Unless you keep them locked in the basement, which is illegal. It's almost impossible to stop somebody from having a relationship that they want to. And then to go one step further, marriage is a fundamental right. So guardianship does not remove that right. You still have, even if you're under guardianship, you still have the right to marry whoever you would like to marry.
And I've had cases where someone's under guardianship with their parents as the guardian, and they get married, and now sometimes they say, I'd like my spouse to become my guardian, and there can be a little bit of an issue or battle with that sometimes.
Can that happen?
Oh, it's happened.
And if someone says, I think that my 18-year-old, my 19-year-old child needs to have a guardian, and I want to remain that guardian, are they able to say, I want complete control, and say that to a judge, and have a judge perhaps say, no, you can only have, not plenary, not complete, but rather this and this,
limited.
but not that, limited.
Right, absolutely.
And they specify that.
So under Rhode Island law, that's how it's supposed to work. And I'm sure, again, with probate court, in all the cities and towns we have, there are a lot of different probate court judges. There's a lot of different guardian ad litem, so you're never quite sure what you're going to get.
And remember, that is a change in the law that's developed over the last decade or so. Whereas before, judges who were judges before that change in thought in law, always just, well, guardianship or not guardianship. It was black and white. It's not that way anymore. So sometimes you have to make sure the judge understands that.
Right, and so not only do the judges not always understand it, but sometimes the attorneys that are applying for it don't understand it. As David had mentioned, on the form itself it says, what alternatives have you attempted? Right. And I've seen attorneys just say, not applicable because they need guardianship. Well, no, that's for the judge to decide, not for you. So technically you are supposed to attempt these alternatives first. And a good judge will recognize that and say, no, you have to go back and maybe try something else.
Can you explain at what point or how the potential guardian or the potential ward gets to have access to information that can make each of them make an informed decision about whether they should pursue each of those routes? How would a potential ward, someone perhaps who's part of the developmental disabilities community, how would they get to know, I can stake my own claim, my independence, I know I can't do this, what else can't I do? How do they get to learn about what they can and how to proceed?
So that's the problem nationally when I quoted that 58% number. Oftentimes parents are getting the information that they need to get guardianship from the school district when a child is 17 and 10 months or almost 18.
Yeah, I've actually had people come in and say, hey, I was told I need to get guardianship because my child's going to be 18 soon.
Right, and that's a major problem. So again, in Rhode Island and Massachusetts, we are better than the rest of the country generally, but it still happens here. There's no doubt about that, and it's something that we need to fix. But when you say, when do you learn this?
How do you learn?
You should be learning that the same time every other child learns independence, right? As you grow, you should be part of your IEP team more and more. You should be controlling what's
IEP means?
Individual education program.
Which comes through each school system.
Yes, if you have a disability and it falls under a certain category, you may be eligible for an IEP, an individual education plan, and the school district might have to alter their educational route for you and provide some accommodations and that kind of thing, and that would be in that plan. Obviously, when you're 3 or 4 or 5, your parents are going to be doing almost all of it, but the point is, as you get older, you should be learning some more independence and be allowed to kind of express yourself some more, to the point where I'm advocating that if you're unsure, bring a friend, bring a classmate. That's okay too. That's a whole nother show. I probably don't want to get into that right now. But that's where you learn independence, the same way everybody else does. And I think, like most 19 or 20 years old, you're probably not completely ready for full independence and still need to rely on your parents, and that's okay too. But that doesn't necessarily mean you need a guardian.
You know, it's sort of interesting. Even without a disability, parents who are spending money to send kids to college have an issue as to, well, I'm paying the tuition, can I see the grades? And no, you can't unless there's a release signed by your child to do that.
Right.
So-
Yeah. Oftentimes, I find the same thing with healthcare. They'll fall under my insurance. You need to inform me. No. Just because they're 23 and on your insurance does not give you the right to get the information or make decisions. Right. And but a lot of times parents think that, and so yeah, that's an issue as well.
So we always try to provide resources. There are a couple of websites that we were going to refer to. You mentioned that there was one for the it's called Supported Decision Making, and we will soon be putting up, yes, we have supporteddecisionmaking.org. Every state has some comparable website that will allow people to have some information about it. But you also, as an advocacy group, you can also speak to the fact that there are other groups that will help usher people along in the process of whether it's education or...
Right. So if you do have questions about guardianship or alternatives to guardianship, you can contact the Bar Association would be one resource.
We like that.
Absolutely. The Rhode Island Developmental Disabilities Council, where I work, you can contact us, or the Rhode Island Disability Law Center. Their website is www.ridlc.org. And they've got information. They're the ones who developed the pamphlet. Oftentimes when I go out to present on alternatives, we do it in a joint capacity. So those are excellent resources.
You talked about alternatives, and I don't know if we've really touched much on the alternatives now that are available that Rhode Island has.
With the law.
Right,
law.
so just recently, this past legislative session, a law passed called Supported Decision Making. And this is another alternative that's available to people, both people with intellectual and developmental disabilities, but we also see it being used for elders as well. Everybody wants to hold on to their own autonomy for as long as possible. And we see this as an option. Essentially what it does is it allows a formal agreement between a person and some supporters. And that agreement can be issue specific or it could be global. So it could be, listen, I need help with everything, and you two will be my supporters, and we have an agreement, and here's how we're going to operate. You can get information for me, or both of you can get information for me. We'll meet back here within a certain amount of time and make a decision. Or it can be very specific. It can be around a financial decision. Should I move into a nursing home? Should I, it could be question specific. Essentially, there's a form. It's a formal agreement. Everybody signs it. It is, signatures are notary as necessary. And now you, my supporters, would have the ability to say, go to a hospital, say it was around healthcare, and get information on my behalf. You could then bring it back to me, help explain it to me, and ultimately the decision still rests with me. So that's where it's a little bit different from a power of attorney, where I say, here's the power of attorney, go do this on my behalf. But the person has the authority to act as you. Here, the person is still ultimately making the decision. And we think this is really important because guardianship or no guardianship, the number one indicator of abuse and neglect is isolation. So again, you don't have to get guardianship to isolate someone, and there are plenty of people who have guardianship over their adult children who make sure they are completely surrounded by great people and have the opportunity to do everything they want. So I'm not, I'm not trying to put anything into a single classification, but when people are isolated, that's when abuse and neglect happens most often. So with supported decision making, the fact that you can have multiple people helping you with decisions is kind of one of the major benefits. Is there's always people kind of around you, and that you can't wipe out abuse and neglect completely, but this certainly should help reduce it.
And would you be able to, as a supported person in this particular area, you get the information and you discuss it, then when someone has to execute on the decision, even if it was your decision, say, can you authorize me then to go and do that on your behalf?
Absolutely. So that can be part of the supported
contract.
decision-making agreement, right? So you would take that, and the hospital, for instance, you would take it and give it to them. They would know what authority you had, and so absolutely, because that's a good point.
Right.
Oftentimes, a person can't make that next
Right,
step.
and I was
once it's
thinking, you talked about in terms for someone who's got a disability, but for someone who's older and just isn't mobile and can't get out, has capacity to help make their own decisions, but now they made the decision they can't get out, they can have your support person go and
Yes.
say, this is what we're going to do.
Yes, absolutely. Now, it can't be a healthcare provider, and it can't be somebody who's like a paid support.
Right.
But beyond that, it can be a friend or family member.
Yeah.
And it's a great point, especially on the elder side. Again, sometimes guardianship does become necessary, but this is something that would be in place to allow the person autonomy for as long as possible.
Correct.
Until the next
Yep.
step had to happen. And so that's why we like it.
So David, we've addressed before that you're involved with the Rhode Island Bar Association, now serving as its president. We've touched on the fact that there are services available to people at no cost, low cost. Might this be a resource for some people who are part of the developmentally disabled community? They might have limited resources, as Kevin was referring to, $700 a month or whatever it is. Would that be a good resource for them?
Well, there's two
Potentially?
things. The Disability Law Center, I'm sure, would be a resource that could help. There's a volunteer lawyer program where I suppose if you qualify under that, you could have a lawyer who could help walk you through this new law that's out there and help. Just like if they thought they needed help with their power of attorney, a volunteer lawyer through the program could help, so they could help through that. And there's a lot of different volunteer lawyer programs. There's one specifically dedicated to the elderly. There's one just for people who have a financial need, and can't afford to hire an attorney.
Do you find, Kevin, that across the states, never mind, I understand in Canada and other countries, they're moving for this supportive decision-making law. Have you seen much interest afoot across other states as well now? Is there really a strong force to try to make this happen?
Yes, this is one of those movements that's really gaining steam, and I believe Rhode Island is I want to say the 7th or 8th state to pass it. The big push happened in Texas originally. It's also, I believe Kentucky, Delaware. I don't want to guess the states because I might get some of them wrong.
It's interesting because I always think of California as like having the cutting edge
Leading
law
the charge.
changes, and then it comes back this way.
Yeah, oftentimes this is. I don't want to knock Texas, but it's a little surprising that Texas was one of the places where it started. And in Rhode Island, there's a supported decision-making coalition, so we hope to get some trainings out soon and really get information out to people, and that includes the DD Council, the Disability Law Center, the Sherlock Center, Advocates in Action, Alliance for Better Long-Term Care, that's kind of the elder side, the Brain Injury Association, the Community Provider Network of Rhode Island, the Cross Disability Coalition, the Rhode Island Parent Information Network, the RI Organizing Project, and a big advocate was AARP.
And it would be a good seminar for lawyers to just, maybe we do those lunch seminars,
right,
just to have some updated information given to lawyers in general, too.
Yeah, that'd be great. I'd love to partner up.
I'm going to hold you to that.
Okay, thanks.
Sounds good. We hope that this session of Law Matters has been helpful to you. We hope you will continue to tune into the Law Matters because it matters to you.